Americans do not give enough attention to the Supreme Court. Most Americans know next to nothing about the Supreme Court or why it should be an important issue for the 2020 elections. Some of the presidential candidates very rarely mention it, most never at all. There was not a word about the Supreme Court in the two recent Democratic candidate debates. The fact is, the Supreme Court, as currently structured, is in the process of destroying our democracy with right-wing 5-4 votes that favor the elites and special interests. It will only get worse if Trump is reelected. First, let me get the biggest scam of all out of the way. That these Supreme Court justices are making their decisions based on the original intent of the Constitution they think is written into the document. This so-called concept of original intent is complete nonsense. The founders never used the term, and it is an impossibility, especially because the Constitution could never anticipate the nature of our society and nation hundreds of years later. But even more, their goal was to write a constitution that would adapt itself to the future, articulating only a limited number of very specific mandates. Other than those, if they were writing the Constitution today, it would be a very different document for our times. They had no idea, for example, about the violent, deadly abuse to which weapons are put today in community after community, or that we would have massive, permanent military to protect our nation, as a current example. The Second Amendment would be very different if being written today. Much more to the point in this commentary is the rise of political parties. The founders could not even conceive of such powerful organizations that would control the fate of government when they were writing the Constitution in 1788, or the many abuses that would result from our party system of government. Most of all, what was in the Constitution were very basic principles, none more important than fair elections. Another basic component of the Constitution, championed by one of the founders, Alexander Hamilton, which was essential and is the doctrine of implied powers. That was not specifically forbidden to the federal government in the Constitution, were in fact powers of the three branches of our federal government under the Constitution. So that both inherently and implied, the Constitution protects fair elections for any and all elected positions within these United States, national, federal, or local. At the same time, there is no appeal to a majority Supreme Court decision, no matter how they rule, no matter how blatantly political the majority on the court are, or how much they deny the basic mandates contained in our Constitution. So that what happened just a few days ago, the most recent outrage by the right-wing Republican majority on the Supreme Court, proves reform is essential. The majority ruled 5-4, led by the so-called Chief Justice John Roberts, and contradicting the most sacred rights in the Constitution. The right-wing majority ruled the Supreme Court, indeed the entire federal judiciary, had no right to enforce fair elections. That individual state legislatures could and do manipulate the election process in any way they like. The Republican majority on the Supreme Court just told us they control the power and that our votes do not count if they don't want them to count. Roberts and the four other right-wing ideologues are a direct threat to our very democracy and Constitution, and reform is absolutely essential. As the court is now structured, these five may have control of the court and our destiny for decades to come, and it will only get worse if Trump gets reelected and is able to appoint more right-wing politicians to the Supreme Court. And by the way, neither do five left-leaning Democrats have the right to this same kind of abuse of power. What does the Constitution have to say about the structure of the Supreme Court? Very little. Only that the President nominates and the U.S. Senate confirms federal judges, including Supreme Court judges, and that judges will be compensated as long as they display good behavior. The Constitution does not require judges be appointed for life or that there be 9 justices on the Supreme Court. The Constitution further states, the judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States. That is it, except for explaining some very special situations that are not relevant here. So yes, there will never be a perfect court, just as there will never be a perfect government. But how we survive and prosper is by eliminating excesses that can destroy our government and us. Most of all, by limiting the amount of time any federal judge or anyone can serve on the Supreme Court. Limit service on the Supreme Court to 1 5-year term. It will be a special honor to be appointed and confirmed to serve on the Supreme Court. For those like most appointees who are federal judges, after they serve these 5 years on the Supreme Court, they can return to being federal district judges or decide to retire if they wish. Congress can make this change without question by passing, just as it does all other matters, the necessary legislation and the president signing it. Just as having a permanent president or permanent members of Congress would be tyranny and a dictatorship and a violation of our Constitution, it is no different for Supreme Court justices. There should also be a spirited debate in Congress about whether or not to increase the size of the Supreme Court to more than 9 justices to ensure more diverse views are represented on the court at all time. Another pivotal piece of legislation that should be passed by Congress is a joint resolution instructing the federal courts and making it crystal clear that our Constitution is a living, evolving core document and that original intent is an invalid doctrine for interpreting the Constitution and its provisions. That the intent of the founders was to create a Constitution that would always be relevant to the times in which it exists, and that fair elections are a singular importance within the Constitution. And parallel legislation that would allow a 2/3 vote of both houses of Congress to dismiss a judge from the Supreme Court during their 5-year term and return them to serve as federal district judges for refusing to follow the guidelines of this resolution. It would not be a punishment, just a judicial reassignment. Such a resolution will not ensure how federal judges in general will rule, or specifically how the Supreme Court will decide important issues, nor should it. But it will be powerful, specific guidance they will take into account. Some will call these few simple changes radical or breathtaking. I certainly do not. I call them a logical, readily available means to fix our dysfunctional, now dangerous Supreme Court that has proven it is out of control in various, very partisan political decisions that favor special interests and not the broad range of citizens of these United States. Made starkly, painfully obvious by its recent 5-4 decision, strictly on party lines, that individual state legislatures can design election conditions in their state that clearly undermine the guarantee of fair elections. And this Supreme Court will do absolutely nothing about it. This must stop now.